of each year Committee, Wednesday, 2nd of September 2026. I'm Councillor David Took. I'm chair of this committee. The meeting is being live streamed and is available to view on the council's website. By attending this meeting, you consent to being filmed. The planning committee is not a public meeting, but a meeting to which the public is invited, and all attendees must comply with the ruling of the chair. Members of the public must not interrupt the meeting or cause undue disturbance. To support this, please switch off your mobile phones or select silent mode for the duration of the meeting. Only those who have registered to speak in accordance with the speaking protocol will be invited to address the committee for a maximum of 3 minutes each. This is limited to the first 3 people objecting, the first 3 people supporting the application who have registered, along with a town or parish council and ward member. No additional material is to be circulated to members of the committee today. We have 2 applications to determine today. The planning officer will be invited to present the report and recommendations. Next, I will invite members of the public who have registered to speak, the Democratic Services Officer, before the deadline to address the committee in the following order: public against, public support, applicant or agent, town or parish council, and ward member. Each speaker has a maximum of 3 minutes. Following on from the registered speakers, planning officers will have the opportunity to address any salient points they wish to clarify, and committee members will be given the opportunity to ask questions of the planning officers before moving on to their debate. At the end of the debate, we will take a vote, and I will declare the decision of the committee. Can I remind members that when we go into councillor questions and debate, please state your name and ward for the benefit of the public watching, and speak directly into the microphones so that we can all hear you. Please remember that the microphones on the table are always on and will pick up any audio during the meeting. If anyone is using Teams, please ensure you're on mute and your device volume is set to 0. Before we begin, just a few final points regarding general housekeeping. We are not expecting a fire alarm during today's meeting. However, should the alarm sound, please leave the building calmly and without delay, using the nearest fire exits, which are located at the side of the room. The meeting will be formally adjourned at that point and will only resume once it is safe to do so. Moving on to introductions, we have officers involved in today's meeting are Kim Cowell,
Morning.
who is the Development Management Eastern Area Manager, Elizabeth Adams, Development Management Team Leader, Thomas Wild, the Project Officer, Carrie Wooldridge,
Morning.
who is a Planning Officer, Kelly Pugh, who is also a Planning Officer, Phil Crowther, who is our Legal and Business Partner, Megan Rochester is our Senior Democratic and Governance Officer, and Josh Kennedy is a Democratic and Governance Officer and is also the clerk for this committee. Josh, do we have any apologies for absence?
Yes, we've had apologies today from councillors Duncan Soweryhouse, Alex Brenton, Scott Florick, and Gary Suttle.
Thank you. Does anyone have a declaration of interest we should make? Yes.
Beryl, as I'm the local member for Wareham, which includes the first item. I am predisposed but not predetermined on this one. I've made no sort of declaration to anybody about this, so I actually free to, I think, to actually take part in the debate. Thank you.
Thank you, Beryl. As far as I'm aware, predisposition is okay. Predetermination is not. We have a nod from our legal officer's confirmation. So thank you for that. Anyone else? No. In which case, you should all have seen the minutes of the previous meeting. Can we take those as read? Any objections to them?
Chairman.
Councillor Coombs.
Morning, Councillor Coombs, further forward. In the apologies of the minutes, there is a member mentioned as giving their apologies. I'll spare their blushes. We all know who that person is. They were not given at the meeting, and yet they are recorded as being given in the minutes of the meeting, and they were not given at the meeting.
Very happy if I go back.
Josh.
Thank you. Yeah, this was raised by another member before the meeting as well. So we've been in contact with the Democratic Services Manager, and that was the system that was in place of recording all members who hadn't attended the meeting as apologies, even if they hadn't provided those before the meeting. So that's being looked into by our manager now. And yeah, hopefully they'll come to a conclusion and rectify any error that was taking place before.
Chairman, can I ask that we have an email when there's a resolution to that, please?
Yeah, I'm sure we will. Finally, in which case, for the avoidance of doubt, Councillor Hobbs-Chell has not actually sent apologies, but is not yet present. Anyone else regarding the minutes? Thank you. This is an item where we have public participation if you wish to speak now. You may, of course, wait until after the officer has given their presentation, or you can speak at this point if you wish. Does anybody wish to speak at this point, or are you all happier to wait until the officer's presentation?
We'll wait.
Okay, thank you. In that case, the first substantive item on the agenda is item 5, which is P full 2026-02113, Hilton Heath Garage, Wareham Road, Hilton Heath, BH16 6JW. Presentation will be by Carrie Waldridge. So, Carrie, in your own time. Thank you.
Thank you, Chair. So this application is to retain the existing petrol filling station, shop and forecourt as constructed on the site with extended 24-hour opening and a lighting scheme, the canopy downlighters and shop fascia downlighting. The application is being considered by the planning committee today because the council owns part of the application site. Members may recall the site from the original planning applications in 2022 and 2023, which were the renovations of the shop, the forecourts, and the new canopy, and also advertisement consents, which were determined later by the planning committee. The application site is located northeast of Algonford and Hilton Heath Industrial Estate, and to the southwest of Baker's Arms roundabout on the A35. And as you can see here, the site is accessed directly off the A351 Wareham Road. And the site is now in use as a BP petrol filling station with a small shop to the rear of the canopy. In terms of constraints, the site is located outside of a settlement boundary and is therefore in the countryside. It's also within the southeast Dorset green belt and the 100-metre heathland buffer. And the part of the site which falls within the ownership of Dorset Council is highlighted in purple here, which is to the front and extending to just over halfway across the depth of the canopy. This photo just shows the site partly through its refurbishment in 2024, and you can see the new canopy to the front and the shop building to the rear. The site is surrounded by residential development on all sides, including the park home site to the rear here, but there is also some commercial uses to the north. And this photo just shows the access to the site as existing from the south on Wareham Road. These photos are just taken from various locations within the site and show you the new canopy and the shop front here. And these are some further photos that I've taken of the site showing the in-out system that's in place for the access and egress, and some of the existing signage showing this flow route to customers. This is the site plan that has been submitted with the application. And this is what's actually been implemented on site. So the principle of development of the site, redevelopment of the site, was considered as part of the former applications. And as previously considered, although the site was in the countryside, given the historic lawful use on the site, the alterations and proposed extensions to the building, the forecourt and the canopy were all judged to be acceptable. And they remain acceptable given the implementation of the consents. The site is also located within the South East Dorset Greenbelt. But the under-implementation of the previously approved consents is not judged to result in inappropriate development that results in harm to the openness of the Greenbelt. And as such, the proposers consider to form appropriate development in accordance with the NPPF. In terms of the 24-hour use, whilst this would change the existing pattern of activity on the site, the additional use would be outside the existing peak hours of customer activity and is likely to comprise passing and diverted trips as opposed to new demand, with limited additional impact on the countryside and greenbelt designations. The petrol filling station is a community facility in accordance with policy I7 of the Purbeck Local Plan. This policy is silent on the extension of opening hours of existing facilities and services, but it does advise that new facilities and services outside of a settlement should meet a need, be located close to an existing settlement or in an accessible location, and minimise impact on the landscape, environment and local character. The petrol filling station forms an existing lawful use that is judged to meet an identified local need given the business of the forecourt. However, as the extension to the hours of use is proposed, this is considered to demonstrate that the local need would continue to be met by the extended opening hours. The 24-hour use would remain close to existing residential development and as an accessible location, being accessed directly off Wareham Road. The established use has its busiest hours of customer use during the day, and the impact of the extended open hours on the landscape, catchment environment is judged to be minimal and acceptable in accordance with policy requirements. For this slide and the next few slides, I'll go through just to highlight the changes from the most recently granted consent, which was a non-material amendment, and what has actually been implemented on site as you see it today. And so effectively under implementation has taken place. So the non-material amendment approval is on the left-hand side here, and what has been implemented is on the right-hand side. As you can see, the rear extension was never implemented, and other minor changes internally and to various windows and doors were also not implemented. A further change that wasn't implemented was an increase in the roof height here, so it remains as the building was originally constructed on site. And this just shows some of the other changes to the elevations. The proposed 24-hour opening of the garage has been subject to objections from local residents on the park home site to the rear, who raised concerns about increased noise and antisocial behaviour and disturbance and the impacts on their residential amenity. It was acknowledged as part of the former application assessments that noise associated with the petrol filling station and the associated retail uses would be limited to the main hours of operation, which generally coincided with peak traffic movements along Wareham Road. Conditions were attached to those consents restricting the hours of use from between 6 a.m. and 11 p.m. And this was considered appropriate to protect the amenity of the neighbouring residents and the rural character of the area, particularly at night time when any amplified noise would be associated with reduced traffic on the road. Conditions on both of the previous consents for the shop and the forecourt and canopy also restricted deliveries to between the same hours, so between 6 a.m. and 11 p.m. However, it is understood from responses from local residents and an online search that the site is now operating at 24 hours in breach of those conditions. This application is supported by a noise impact assessment, which concludes that the noise climate of the site is always dominated by traffic on Wareham Road, and that during the daytime and evening operations, opening hours, the forecourt activity has negligible impact. The noise assessment also found that overall noise levels showed a small drop as the night progressed, but the forecourt activity made no contribution to the measured noise levels, and that the forecourt noise generation was dominated by general traffic movements. Consultation on the noise assessment has taken place with the Council's Environmental Protection Team, who have confirmed that they have no adverse comments regarding the standards and the methodology used in the assessment. They also note that the assessment concludes there will be a negligible impact due to the existing dominance of noise from the road traffic, and that the forecourt activity at night will correlate closely with the general traffic volumes along Wareham Road. No objection to the proposed 24-hour opening is raised by the Council's Environmental Protection Team. However, this is subject to conditions. So the first condition would be that no deliveries and waste collections would be made at the site between the hours of 6 a.m. and 11 p.m. And this is set out as condition 3 on page 26 of the committee report. And just to clarify that an update sheet was circulated to members in advance of the meeting with some amendment to that wording, so it's very clear in terms of interpretation of the condition. The second condition that is recommended is that retail sales are restricted to the serving hatch only between the hours of 11 p.m. and 6 a.m. And a third condition is recommended that all forecourt announcements are restricted to a speaker at the serving hatch only, with no tannoy or loudspeaker use between the hours of 11 p.m. and 6 a.m. So that's conditions 3 and conditions 2 of the committee report set out on page 26. The original consents also included a condition to control external lighting at the site, with the aim of ensuring that it was appropriate in relation to the neighbouring residential uses and the visual amenity of the area. This condition was never discharged when the consents were implemented, and is sought to be addressed by the current application. So the current application is supported by a lighting scheme, the downlighters below the canopy, and further downlighters on the shop facing the forecourt. The totem pole to the front of the site has previously had separate advertisement consent, and so does not form part of this current application. So lighting assessment includes wall down lighting on the front of the shop in the yellow positions, yellow dots highlighted here, and a dimmable under canopy down lighting at various points below the canopy, which are highlighted with the purple dots. The assessment advises that the lighting levels will be adjusted according to the time of day and night and will be dimmed during hours of darkness. Horizontal cut-offs of the downlights will ensure the light is angled down towards the ground surface. The lighting report concludes that lighting satisfies one Lux criteria with neighbouring properties whilst being adequate for the on-site activities. The Council's Environmental Protection and Highway teams have been consulted on the lighting scheme and have raised no objections, subject to a condition on the consent requiring installation and implementation in accordance with the details that have been submitted. And that is recommended condition 4 in your committee report. So no alterations are proposed to the site access egress as part of the current proposal. Nevertheless, neighbours and the parish council have raised concerns over impacts on highway safety associated with both the existing and proposed 24-hour use. The Highway Authority has been consulted on the 24-hour openings, and they have advised that the trips generated outside the normal business hours are unlikely to coincide with the peak network periods, which are between 7 a.m. and 9 a.m. and 4 and 6:30 p.m. The proposal is not therefore judged to have a material impact on the operation of the highway network. The Highway Authority have also noted that whilst there be some increase in vehicle movements associated with 24-hour use, these are likely to generally be diverted or linked trips rather than specific new demand. As such, the proposal is not judged to result in severe impacts on highway capacity, and safe and suitable access to the site is judged to be available for all users in accordance with the NPPF. The Highway Authority has advised that they find no sustainable reason to recommend refusal of this application. Neighbours have raised concerns over the use of the exit of the garage, which is here, the northern access exit onto Wareham Road, and the impact of this being used by customers to the garage leaving the forecourt, which has sometimes resulted in the exit being blocked. This also serves as an access to the park home site to the rear, and on occasion abusive behaviour towards the residents of the park home site as a result. So as you can see from these photos, the in and out lanes to the park home site are demarcated on site by directional arrows, and there is also, as already advised, an in-out route through the petrol station forecourt, which aims to avoid conflict with the access and egress of the park home site. It's also noted that this in-out access and the directional arrows provide some betterment on the previous lawful use of the site, which was not subject to any sort of signage or restrictions. And the existing position is considered to be reasonable. The 24-hour use of the site would further disperse the customer use over a longer period, and as such, it's not considered reasonable to condition any further measures at the site in terms of arrows and signage on grounds of highway safety. Other concerns raised by local residents include increased litter and antisocial behaviour. Officers consider that it's exceptionally difficult to link the 24-hour use of the site with an increase in litter. As a case officer, I have visited the site on several occasions and have identified at least 6 rubbish bins, around 2 in front of the shop and 4 on the forecourt next to each of the petrol islands. Given the number of rubbish bins present, this is judged to be sufficient for the existing and 24-hour use. In terms of antisocial behaviour, the 24-hour use would mean a permanent employee being present on the site, and this associated with the nighttime lighting scheme and the CCTV present on the forecourt will act as some form of deterrent. More substantial antisocial behaviour could, however, be reported fairly quickly to the police, given the 24-hour staff presence. In summary, the retention of petrol filling station and retail unit in forecourt as constructed in its under-implemented form is judged to be acceptable in terms of layout, scale and design. The proposed 24-hour opening is supported by noise and external lighting assessments that have been reviewed by the Council's Environmental Protection and Highway teams and are considered acceptable in respect of impacts on neighbouring community and highway safety. This is subject to the conditions set out in the report. The application is therefore judged to comply with policies of the Purbeck Local Plan 2024 and the NPPF. And there are no material considerations that indicate that permission should be refused. The officer recommendation is therefore that planning permission is granted, subject to the conditions in the report and the amended wording of condition 3 as circulated in the update sheet, which will ensure that no deliveries and waste collections can be made to the site between the hours of 11 p.m. and 6 a.m. Thank you, Chair.
Thank you, Carrie. We have two public speakers on this. I understand that Alan Poole is going to be the first speaker. Alan, if you take a seat at the small desk there, you'll see a microphone in front of you. There's a couple of silver buttons on the front of it, one of which represents somebody speaking, and you've turned it on, so it works, I hope. Thank you. So,
Good morning, everybody.
3 minutes, and you'll get a 30-second warning.
Right. I've got 11 points because there's quite a few were objecting to what the ladies just said, because the garage itself is surrounded on 3 sides by houses and bungalows, a lot of which are old age pensioners, and which are affected, because I live immediately behind the garage and I get affected most by all this, what's happening at the garage. We get constant noise from the garage, from their equipment, the fans and the air conditioning unit, which nobody seems to bother fixing. There's very little traffic on the H351 from about 7 o'clock in the evening right away to 6 o'clock in the morning. So there's no real need for the garage to be open at those sort of times, just the odd car. We're expecting, if they do open 24 hours, we'll get additional noise from vehicles revving up, as they do when they fill up quite often. And some of the traffic is really quite loud. They do actually wake us up if we're asleep, some of the traffic. I mean, they park on the front now, which they shouldn't be doing because it's council property. There's additional noise from, which was not mentioned, there's a food container that's at the back of the shop. That is very noisy every time they open it and close it. It's not a normal storage, it's a food actual container. They're quite often in there, sometimes between 4:30 and 5:30 in the morning, which wakes us up. There's plenty of time they can get into there between 7 and 10 o'clock at night when the garage is quiet. They could sort things out between those hours. The container itself was supposed to be a temporary measure while they've got another building built, and there is another thing being built. It's a plastic, not a container, but a temporary sort of building. And that is quiet. If they use that, it wouldn't be a problem. Bin collections was mentioned was going to be after 6 o'clock. Quite often that they're opening all the fences there between 4:30 in the morning to allow the. Sorry.
30 seconds left.
Well, between 4:30, they could sort that out in the evening. Yeah, the workers there have no respect for people on the park. The shop's been broken into already 3 times, and it's going to be possible for more. They're already opening outside the planned house 6 till 11, which they shouldn't be. So they're always applying for things respectively.
Thank you.
Canopy lights.
Can you wrap up now, do you think?
Yeah, canopy lights are too bright. They're shining into the bedrooms. Even we've got blackout curtains. And the other thing is, everything they promised, they've not delivered on. They tell lies.
Mr. Paul.
Thank you.
The next public speaker is Christine Wilson. And again.
Good morning, ladies and gentlemen.
3
I
minutes.
moved on to Holton Heath 10 years ago. I'd been living in Poole, where incidentally I used to sit on a planning committee. I moved for peace and quiet. 2 years ago, that peace and quiet was shattered when the garage was opened. We had various promises made by staff and a manager who was there on the opening day that there wouldn't be any problems, our access would be safe. And those things haven't happened. And this is why we're very sceptical about provisions for 24-hour opening. The directional arrows are ignored by drivers, and the garage didn't put those down. The owner of the park put those down. I've been shouted at, sworn at, as have other residents. And once I was actually forced to back out into oncoming traffic because a caravan refused to move and the whole forecourt was blocked up. We now experience intrusion onto our park by garage users. We've had people walking their dogs. We actually have people coming onto the park and urinating in the corner. And that, if the shop is open 24 hours, that could happen a lot more. I don't know if if you intend the toilets to be left open. As regards, I noticed you said any retail sales would be through the hatch. I'm assuming that's just petrol and not alcohol. As Mr. Paul said, there is very little traffic on the road at night, apart from the occasional boy racer and quite often a lot of boy racers. And we feel that the open forecourt could be a magnet for antisocial behaviour. I'd like to mention a couple of things in the report. On paragraph 12 at the top of page 19, it refers to a disabled space. Somebody needs to get their eyes tested because there is no disabled space on that forecourt. There is parking, yes, but there is not a disabled space marked out. I also note on item 1414, assumption that the drivers will be alone. So that's going to add to noise. You might get the odd lone driver, but usually people have got somebody with them. Mr. Paul has mentioned about the lighting. 14.26. It is not
30 seconds.
It is not considered reasonable to condition any further measures in terms of highway safety. The drivers park wherever they want. If I was on the forecourt the other day, there were people parked by the door, there were people parked at the petrol stations. We need access, pedestrian access. It's not safe. And the barrier they've put up between the garage and the road is often moved. It's not safe. I dread coming home now because I don't know if I'm going to be abused or whatever. Thank you.
Okay, thank you very much indeed. Do the officers have a response?
Yes, thank you, Chair. Okay, so the actual need for the petrol filling station is more of a commercial consideration as opposed to a planning consideration as part of this application over the 24-hour use. If they feel the need is there, then obviously they can apply for 24-hour opening if they wish to. The food contained in the rear of the site is likely acceptable as an ancillary use on the site, but we can certainly look into that further if necessary. The alcohol sales would really be restricted by a licence as opposed to the planning consent. So if you were to grant consent for 24-hour opening today for the retail use, that would allow the sale of alcohol, subject to the applicant having the appropriate licences to do that over the 24-hour period. And that's a separate consideration to the planning application, separate sort of legislation requirements. The disabled space, as I understand it, should be to the front of the shop, adjacent to the roller shutter. I can certainly look into that on site again and follow that up with the planning agent to ensure that it has been implemented or is implemented. And use of the site by boy racers stopping, unfortunately, that's something we don't have control of. If they use the highway to pass the site, and then they are using sort of private land in the forecourt, that would be an issue for the garage owners to implement in terms of them causing issues to neighbours, or as I mentioned in my answer presentation, you know, if it's antisocial behaviour taking place, to contact the police about that. Thank you, Chair.
Thank you. Do we have questions from members? Councillor Azad.
Thank you. Councillor Beryl Azad, Wareham Ward. Yes, I've got questions on, could you tell us what the current opening times should be? And I've looked online and found that they are contravening that, where they advertise 24 hours. And I think they've been doing that for some time, as some of the residents are saying in the park homes. So has any action been taken of that as well? That's another question. And also, can I just tell everybody here that although I welcomed the actual filling station a couple of years ago because it was a really derelict site, no way were the parish council or the local members willing to allow it to be open 24/7. And that was one of the ones we were vehemently opposed to at the time. As the planning officer is saying, they can apply for 24 hours, but there is, can I just mention that the park homes are for retired people. There's 65 of them, and they're immediately behind. If you look, can we look at the picture, how close they are at the back of the site? And as the gentleman was saying, Mr. Alan Poole was saying, he's actually right behind the shops. What's the distance between the filling station, the shop, and the park homes? It's very close, and I would say that actually having, the actual garage or filling station open 24 hours is going to not be, very neighbourly, and also going to spoil their, quality of life. So with that nighttime opening, so I was going to say, please, would you answer those questions? And also, would the committee be aware that Sandford also has a filling station less than 2 miles down the road, and Stobra 4 miles down the road, and they've got similar opening hours. And also Fleet's Bridge, which is less than 5 miles towards Poole, has a 24-hour opening garage there. So when you say there's a local need, I would say there was not. But can you answer the questions I've asked, please?
Thank you, Beryl. Harry.
Thank you, Chair. So the opening hours which have consent, which are conditioned on the previous consents for both the shop and the use of the forecourt, are opening between 6 AM and 11 PM only. And as set out in my presentation, that I agree that online it does say that the shop is already operating 24 hours. I'm not aware that we have received an enforcement inquiry for the 24-hour use, but obviously this application has been submitted to us to look to lawfulise that position. In terms of the distance between the shop and the nearest park home sites to the rear, so from the front of the shop where the main entrance is, you're looking at about 15.7 metres to the nearest park home site, rear elevation I'll say, and from the back of the shop to the nearest elevation of the park home unit, approximately 8.5 metres. And what I would also point out though is obviously the previous applications followed an existing commercial lawful use on the site, over which officers had no control because there were no restrictions or conditions because it's been lawful use for such a long time. So there has always been some form of commercial use on this site, which may always have impacted on the residents of the Park Home site. So we have to take that into consideration as well as part of our assessment. That answer everything, Councillor Ezra?
Yes.
Thank you.
Thank you. Councillor Ray Bryan.
Yes, thank you, Chairman. Councillor Ray Bryan, representing the ward of St Leonard's and St Ives, which is over by Ringwood. I know this area quite well. I know exactly where the proposal is. I've got to say I'm a bit disappointed that if there is a breach in a current planning, which there is, why no action has been taken by this council? If you're saying it has to be reported to you before the breach will be looked at, I think we need to look at that policy, not for this meeting. We need to look at that policy because it should be that if something is known to be happening, then we should be taking action. The portfolio holder is sat behind me, so hopefully he's hearing what I'm saying, because I think that needs to be looked at. We're talking about 6 AM to 11 PM. You're talking about the distance from the site to the park homes. I've been involved in the park home industry for quite a considerable amount of time. No longer am I, by the way, just so I don't get across a line. But I know full well that the mobile homes have quite good insulation, but it's not perfect. It's not brick, it's wood with insulation or other materials with insulation. You mentioned in your report that lights will be dimmed. Can you tell me how that's going to happen? Is that an automatic dimming at certain hours, or are we reliant on the occupiers dimming the lights themselves? Because if they can't stick to the hours, I can't see we can rely on them to dim the lights. Rubbish bins been emptied. If this was to go ahead, I'd like to see something put in there which says they can only be emptied at certain hours. I think that's only fair on the residents. One of my suggestions would be, could we look, if this is going to be granted, could we look at further screening between the garage and the mobile homes? Because it's absolute. I fully understand where the residents are coming from on the noise. I have a personal experience of noise where I live. So I know how damaging that can be, not just to your mental health, but also potentially to your physical health, because you're not going to go and have a walk round when you're being challenged. And from what I've heard this morning, there is a certain amount of challenging going on. Can I clarify that the garage has been open for 2 years? Because I wasn't sure whether that's the case, because I thought earlier on it was mentioned that it was refurbished in 24. So is the refurbishment part of the existing one, or was the garage a new one 2 years ago? Chairman, if I may, can I reserve the right to come back on at a later date if necessary?
That's fine. Thank you. Terry.
Thank you, Chair. So I'll start with the most recent question, which was how long the garage has been open. The most recent consents for the garage to open between 6 AM and 11 PM, including the forecourt, were granted in 2022 and 2023. The aerial photographs I have suggest that the garage actually opened sometime in 2024, but I don't have an exact date for when it reopened as a sort of functioning garage. Before that, there was always a lawful commercial use on the site, which could have reopened at any time without requiring any additional consents. So my guess is garage probably reopened towards the end of 2024, early 2025, but I don't have a specific date. In terms of when people can empty rubbish bins, I'm not sure that's something we could condition. Yeah, sorry, we do have condition 3 on the consent, which looks to ensure that there's no waste collections from the site by commercial waste vehicles between the hours of 11 p.m. and 6 a.m. But to add in there the actual emptying of rubbish bins within the site, so the various 6 bins on the forecourt, for example, I think would be very difficult for us to enforce, and would therefore be judged to be an unreasonable addition to that condition in accordance with the NPP Act. The lights dimming. So the lighting report which has been submitted to us advises that the lighting control system will be programmed to dim the lights at night to reduce the visual impact and light spill, and that will be conditioned to be implemented fully in accordance with the report. Hopefully that's answered all your queries. Sorry if I've missed any. Sorry, yes. Sorry, Chair. There was another one that lists just screening between the mobile home park and the garage site itself. As I understand, there's already a wall along the rear boundary of the site that has been there for some time. And I think because of the previous lawful use on the site, again, it would be unreasonable for us to ask for any additional screening on that boundary. Thank you, Chair.
Can I just ask, alongside Ray's questions, enforcement is something that has been raised in a number of different meetings across the council, different committees. If operators are in breach of conditions and enforcement takes place, the normal response, or the first response to an enforcement request, is to see if that behaviour can be legalised by giving planning permission for it. So if somebody's in breach of house bill, can they have retrospective permission? But if that doesn't happen, what powers does enforcement have to actually prevent this behaviour? Could it possibly result in, if they don't adhere to the conditions, would enforcement be able to close the site down, for example? My second point, again, is to do with condition 3, which, if I remember the reworded version, was that no deliveries or waste removal. Is emptying bins not part of waste removal?
Thank you, Chair. So if a condition is breached and the enforcement officers are unable to sort of make any progress with the applicants or agents to rectify that breach, then the council can issue a breach of condition notice to the applicants, and then we would go through the sort of standard enforcement process where they would have time to comply with that breach of condition notice. If they didn't, they could appeal against it. So it could be, apologies.
Legal.
Thanks, Chair. Sorry to cut across as well more bridge. So the options for enforcement are council can issue an enforcement notice against a breach of condition, and if that's not complied with, there is an appeal against an enforcement notice also have the option of issuing a breach of condition notice, but there is no appeal against that. The only way of challenging a breach of condition notice is by judicial review. And failure to comply with either enforcement notice which has taken effect, either because it hasn't been appealed or because an appeal has been dismissed, or a breach of condition notice which has taken effect is an offence, so it's enforceable by prosecution. Thank you, Chair.
What that prosecution resulted potentially?
Chair, I can't remember off the top of my head what the sanctions are for a prosecution, but I think for a first offence it's likely to be a fine. For further offences it would be a greater fine. I can't remember whether custody is a sanction, but off the top of my head there may be custodial sentences which would apply for multiple breaches or multiple prosecutions.
Thank you. And on the second part, which waste removal is, does that not cover emptying bins?
So the condition 3 was drafted as set out in the supporting statement to take into account waste removal from contractors at the site, so large bin emptying. I'm not sure whether it would be sufficiently worded to include the emptying of bins within the site itself, or whether it would be reasonable as advised to include that in the condition, because it would just be something we would struggle to enforce against, and would then be considered unreasonable and not sort of in compliance with the tests of the NPPF.
Okay, I'm just reading condition 3. It doesn't actually seem to mention commercial vehicles. It just says no waste removal.
Waste collection.
Waste collection. Go with that. Sorry, Ray, I jumped in. Ray, I apologise, and I've also got 2 further speakers. So
I never mind you stepping in, David. Couple of points.
I'll hold you to that.
I keep hearing this. It's unreasonable. It's unreasonable. It's unreasonable. What is unreasonable is when residents have their lives destroyed by commercial activities that are on the face of it, and I'll be careful with my wording, seem to be out of control. Anybody that wants to amend their hours needs to seek planning permission, but on this occasion it seems they've already taken it for granted. They're going to get it. They've changed to 24 hours on their website. Have we at any stage, knowing they've changed it to 24 hours, gone and seen whether they're operating outside those hours? Do we have any information on that? Because I think that's fairly key to the trustworthiness of us granting this. I take your point on the brick wall. How high is the brick wall? And does that mean that we can't ask them to install some sound barriers and light barriers on top of or alongside the brick wall? Again, I think you used the word unreasonable. But again, I go back to the fact that we have to be reasonable to the residents we represent, as well as the businesses that we encourage. But businesses need to be encouraged to work with the residents, not in conflict with. Thank you, Chair.
Thank you. In terms of trustworthiness, I think that's something that would need to be established post fact. Councillor Skeets.
Thank you, Mr. Chairman. Andy Skeets, West Moors and Three-Legged Cross. I regard what Ray has said as something I believe too. I am concerned that the impact on the residents over the extended period would be very unreasonable unless there's some measures to prevent some of the noise and light intrusion. I get that there's a plan for lighting we haven't yet established whether that is automatic or not, but I think it should be. I don't think it should be something that is left to someone's desire that actually runs it, given the history that you already have of that operation on that site by a very big company, a multinational company that strives to keep pace and work with the environment. The environment of this particular application is pretty heavy on the local residents, and I don't think there's enough protection for them. So I'm mindful to ask whether we can we enforce an acoustic fence of a reasonable height. I don't know the site's elevation in terms of or orientation in regard to the sun, but at the moment, if that was a 6-foot fence, it would help if it had an acoustic value to it and not just bouncing off of a brick wall. So I'm guessing that one of the things that we could add, if we were to go forward and accept this, is an acoustic fence could be maintained around that site in order to alleviate the issue of noise. The other issue here for residents is the change in terms of from 11 o'clock at night. There's whether we reduce the light or not, the impact of people turning up and coming close to the residents, which they never had before. That site was quiet. I think it was almost, I don't want to say derelict, but I never actually, as I was travelling along there, I didn't used to see much operation of anything happening on that site at all much. So they've gone from it being a very quiet site to a site which obviously is expanded in terms of its size, impact on the local environment, probably way beyond the first application. So they've already broken rules, which I find really hard to take from a multinational of that stature. I think it's very poor, and I think that in our deliberation we should be mindful of the fact that what we put into an acceptance, if there was one, should be something that should happen prior to the use and change as well. I'm not happy on the impact of the local residents. I guess you don't have to prove need, but I find it quite hard to imagine that it not impacting on the residents in a heavy way, and I think far more than probably our report says. So is that possible? Can we actually put that acoustic fence around? Can we ask that to be added to the recommendation? And if not, why not?
Officers. Can we condition noise prevention?
Members, I'd refer you back to the officer report and the comments in the report we received from Environment and Health, and from what some of the speakers said about the occasional use at night. They've talked about people driving down the road at speed or whatever it is, that sort of antisocial behaviour within the carriageway and parking. The application is to extend the hours. If members consider that by extending the hours, there would be increased activity and issue. But the report and what we've heard from some of the antisocial behaviour, rather than additional use that would justify this these measures, I can't see in the report that there's any evidence. And we've had before, when we end up at an appeal, that it's all based on evidence. Where's the evidence of the level of use over and above what's been permitted to justify those things being put in place? That's my concern here. You've got an operation that's regularised. There was an unregulated garage here before that had permission. We've then regulated it coming back into use. members have put those hours of operation on there to try and regulate that use. They've breached that. They've now come back in to say, we want to extend those hours. So if members don't think that that's acceptable, you can refuse the applications because you think that extension of hours would cause harm. The concern there that officers need to focus on is that part of the report where the evidence that's been submitted through the noise impact assessment, which we've heard from the neighbours that they're countering that. What do you have to evidence that that use over the early hours of the morning has escalated? Does that help? Sorry for my ramble.
Thank you, Andy.
Yeah, if I can come back, clearly the garage wouldn't try to open for 24 hours unless there was a pretty constant use that warranted the actual payment of staff and manning of the operation. So I don't know that we really need to have to prove that people are going to use it, because one assumes that people are going to use it. I wasn't commenting on antisocial behaviour, but we all know where certain things are sold and open late at night, that they can be they can bring problems like that, but we have no evidence of it. But what we do have evidence of is there is a change here from 11 o'clock at night. The residents that currently get some respite from the accessing of that garage, the use of the shop and the lighting and everything that goes with it. Even if it's controlled, it still has an impact. So the residents probably are used to the sound of road noise going by. It's not really going to impact upon them, but sudden changes to noise, like somebody coming out and shouting, screaming, or just having a good time when they're using the shop and the petrol station will. So the environmental impact on those people is significant, in my opinion, and I'm mindful to just listen to what other councillors say before I make a recommendation.
Okay, thank you, Councillor Scopes. I note what Ken Cowell said in terms of the environmental report. But next we've got Councillor Coombs.
Thank you, Chairman. Councillor Tony Coombs, Burwood Ward. I remember when this came to committee to bring the garage back into use. And the reason that we keep seeing it is because there is land interest held by Dorset Council. Can I have slide 3 up, please? Because that shows the land holdings. So I'm going to pick up on the comments that have been made about traffic use and the access to the home site. So we can see where you've got the junction with the main road, that area is marked purple as being Dorset Council owned land. We've got the red outline of the site. Who owns the stretch of access road adjacent to the red line behind the purple? Is my first question.
Thank you, Chair. We understand that's within the ownership of the Park Home site. Okay. So I've listened very carefully to what the residents have said about antisocial parking. I think is a really polite way of describing it, along that access road. Although it is a private access road, not highway, there is the potential to put down double yellow lines. They would not be enforceable because it's not highway. However, it does act as a visual reference to people to say to keep that area clear. And that would have to be down to the landowner to look at that, and also no parking signs to try and ease everything for the community. But that's not something we can deal with the planning application. But I sort of say that really for your reference to take away and for something to think about. But returning to the opening hours,
It's one of the hardest things sitting on planning committee that you learn is that, yes, you should get planning consent before you do development. However, in law, you can go ahead, but you go ahead at risk. And the risk you take is that you don't get retrospective planning permission and then enforcement action is taken. In a lot of cases, as in the current one, you then, the perpetrator, for want of a better word, then puts forward the planning application to regularise what they're actually doing. So it gives everybody a chance to actually look at the pros and the cons of what's going on. So as much as we dislike retrospective, it's enshrined that that is a way that people can act, which is immoral, but there we go. That's where we are. I'd already picked up about what my colleague Andy was saying about the potential of acoustic fencing, bearing in mind that we've gone from nothing on site for a long period of time. It had been empty for many years. We then allow it to come back into its established use with conditions. We're now looking at an escalation of activity on the site, notwithstanding the comments of environmental protection about the noise impact assessment. It's about the increase in disturbance, even if it is within supposedly acceptable levels, given the distance of the nearest residence to the back of the site. I don't think it is unreasonable for this council to request that acoustic fencing is put along that back boundary to help ameliorate, and it's good neighbour activity. So I'm going to be very brave this morning because we have very little wriggle room, but I think we would be better in trying to put some conditions around it rather than turn it down, because if we turn it down and they go to appeal, they might get it as is with no other protections. So the compromise, and I'm sorry, planning is quite often a compromise, that we try to make things better for the residents. I don't think we have enough to turn it down, so I'm going to move approval with the amended conditions, but I would like to pick up what's been said about the noise impact and the fact that we do add a condition because of the escalation in impact on the residents, given the proximity of the first the homes, is that we've asked for an acoustic fence to be put up along that rear boundary where the wall is. I was going to ask initially if we'd done anything like that with the first application, but I don't recall any boundary treatment being looked at, which perhaps is an oversight then, but because it was only going to be daytime operation, whereas now it's 24-hour operation, and even though it's low numbers at night, noise does travel further and appears louder because there's very little other background noise. So the perception is the increased impact, and that's why I would ask that we have an extra condition to do with acoustic fencing. I think I've worked it out for myself, but can I just also confirm that, because I looked at the deliveries and waste collections, I thought 6 till 11. By golly, that's quite late in the day. But I think I've picked up in the report that they've already got those hours for those. So it's very difficult then to pull that back because we've already granted that. Because I would like to have made it earlier, but I think our hands are tied on that one. So, Chairman, I will move approval with the officer recommendation with the addition of an acoustic fence on the rear boundary for the benefit of the residents.
Thank you, Tony. In terms of the wording of such a condition, would that be due to cumulative impact?
Yeah.
Or
Because of
what sort
the
of
increase in activity and the perceived increase in impact on the residents.
and
And I would leave
what would the form of words that you want to put in actually be?
I tried
I
to.
know. Yeah, think on your feet.
I'm sure that Kim's got enough there that she can put into words of what I've said. Because I've been trying to be very clear about my reasons.
You can try and put it into some wording. Can we have a short time to be able to
And the other thing I would say is I would leave the details, because we've been with acoustic fencing issues before, but we make sure that we have materials and construction and height properly evidenced in the plan of what they're going to put in, because we've had it before with supermarkets where they just put up an ordinary what do they call it? Wooden fence, but a feather edge.
Yeah.
And no acoustic fencing. This has to be proper acoustic fencing, and the details of which need to be submitted and agreed by the planners.
Okay, that covers what you wanted to do. Yeah, okay. Kim, do you
We're
want to?
trying to assist by drafting something to clarify Councillor Coombs's
Okay.
understanding.
We'll,
Can we have a five?
we can take a 5-minute adjournment whilst the officers try to assist with the wording on that. And come, so if we make it 5 minutes, I hope, is that enough?
Yeah.
Yeah, so 5 minutes, it's 11 past, so 16 past.
Thank you, Chair. So
Okay,
officers,
thank you.
Sorry, I've come through with that. So, Chair, through you,
Yeah.
officers have taken on what Councillor Coombs has said, and hopefully, the wording on the screen adequately reflects Councillor Coombs's intentions.
First question is Councillor Coombs. Is that
it does. Who needs AI, hey? We don't need ChatGPT. I'm really pleased with where they've interpreted and also put in the mechanics around what I was asking for, so that it's very clear about what they can do and how they can do it. I have been asked if I will allow some finesse to the wording post this meeting by the officers, not that to change the essence of it, but just to tighten up the wording a little bit so that we absolutely button down that it's absolutely clear what we're asking. So with that wording that has much improved what I said out loud, I'm happy to move approval, Chairman. Well, not happy, but you know what I mean.
I do indeed.
But this is an extra condition with what's printed and the informative note.
This will be condition 6, is it?
Condition 7.
Condition 7. Thank you. Councillor Skeets, you've been patiently waiting.
Andy Skeets, Westmoreland and Three-Legged Cross. I'm happy to second that recommendation. Happy is probably not the best word to be using because I would have liked more protection, but I'm mindful of the fact of appeal, and that's why I've supported the recommendation amended.
Thank you. Councillor Azard.
Thank you, Chairman. Councillor Azard, Wareham Ward. I would like to actually oppose and refuse this application on several grounds. In the report, it's number 11, human rights, which is Article 8, right to respect for the privacy and family life and home. And also in your report 14.12 in the report on page 21, which I don't know, I can't think of what that was, but it's also about quality of life and the local amenity. And you mentioned about it being on Greenbelt, and people that actually come to the park home site think it's going to be a quiet retirement area, and it's not anything like that at all. And also you mention in the report that there is a local need, and the applicants put in there's a local need for this extension of their opening. And the fact that they breached the conditions, you can't trust them. And also the fact that they put in an ATM, which is the cash machine, and had to retrospectively get planning permission for that as well. They can't be trusted, and I think that actually having somebody right next to 65 park homes as volatile as this, and somebody who will not actually cooperate and do what they are supposed to do, is actually abominable and not right for park home owners. And I think this means that we do need to oppose these big conglomerates that are put in for this. And even though they may appeal, I would like to actually oppose this granting and refuse it on those grounds. Can you just bring up those things in the report, please?
Councillor Azad, if you're proposing to refuse this in opposition to the officer's recommendation, then can you clearly lay out?
Point of order, Chairman.
The counter proposal is a proposal that's been seconded on the table. So if she wants to vote against it, if that is lost to make a proposal.
Yeah, legal's just reminded me that we do have an active proposal that's been seconded on the table. So that will need to be voted on first. If it falls, then you can make another proposal. If it falls and you do make another proposal, you'll need to identify the material planning reasons that you rely on for that proposal.
Those are the ones that I mentioned here in the report.
Let's take it
Thank you.
one step at a time.
So, sorry, can I just clarify? If somebody opposes the proposal to actually grant it, and that is carried, you're talking about the second and that's carried, then obviously that's the end of it. Usually, if you want to put in an opposition to that, this is the time that you do it. Is that not right?
No.
It's all the decisions made.
No, if there's a proposal on the table that's been seconded and that gets voted on, they're perfectly free to have a little bit of debate post that proposal being made. But you can't make another proposal that negates it until it's been voted on. If it then falls, you will be able to make another proposal.
Thank you.
And see if somebody seconds it.
Thank you.
Okay. So, do we have any other debate items? If not, then we have a proposal to approve the application subject to the additional acoustic fencing condition, which is on the screen. Can we take a vote on that? All those in favour, please show. 1, 2. All those against? 1, 2, 3, 4. So that proposal falls. Do we have any other proposals? Is the next question. I'm assuming I know the answer.
Yes, I oppose this granting of this application on the grounds that I've already mentioned just now. But anyway, it's in the report, number 11, about human rights, Article 8, the right of respect for privacy, the private and family life, and home. And the other thing is in 14.12, the report on page 21. There's some things in there. So, yes, I mean, what I mentioned about it is a green belt and people come and live there on the understanding that it's going to be very quiet and they're not going to be disturbed at night. And I think this is the most important thing. It's the quality of life for the local people. So it's a local amenity for them. Because at the moment it's making their lives hell.
It is.
Thank you.
Thank you, Councillor Azaz. I don't think green belt is relevant.
Yeah.
However, legal. Can you
Need a second over?
Chair, just wanted to give a little bit of advice around Councillor Azad's reasons around human rights. So, the Human Rights Act effectively is an overarching duty to consider the articles that are protected. Article 8 is a qualified right, so it's not an absolute right, and effectively the planning system complies with Article 8 and the balance by having a system whereby you're balancing the rights of individuals against each other and the public. So my advice would be you need to turn your concerns around Article 8 into planning reasons rather than human rights issues. By doing so, you will automatically address the human rights point as well in effect, but you do need to give planning reasons rather than human rights reasons.
The other reasons, I mean, I've got the material planning considerations here, noise or disturbance resulting from, including proposed hours of operation. That is something you've got to take into consideration. That is a material planning consideration, I understand. And I would say I would look at the loss of privacy that these people have got now because of the garage, and that it would be for 24-hour use. And I just mentioned that the narrow road that goes into the site, which is owned by the park home owner, is not actually, nobody parks there, they park in their car park, which is further down, and they walk the dogs, as they said. So they haven't got the privacy that they used to have. And that is one of the other things. So that's another one, loss of privacy. So if you look at 14.12, can you just look at that, please? Do we have it up on the screen, possibly?
It's in the report.
Yeah. 14.12, yeah.
Yes. Page 21.
P32. P3 bracket 2. I need to make corrections. Just a correction for policy reference. Through you, Chair, if I may. There's a typo. The new MPPF came out in the middle of this agenda publication, so I'm just going to correct the policy reference. But at the national level, I'm going to read from the report because you've all had a copy of the agenda. The officer presentation is a presentation. It's not the agenda, but I can read from the agenda for your benefit. At the national level, this is from policy 14.12 of the officer report. At the national level, policy, and this is the correction, P3 open brackets 2 of the MPPF 2026 requires planning decisions to ensure that new development is appropriate for its location, having regard to the likely effects, open brackets, including cumulative effects, close brackets, of pollution on health, living conditions, and the natural environment. In doing so, decision makers should seek to mitigate and minimize adverse impacts arising from noise, significant adverse effects on health and quality of life, and protect areas valued for their tranquility, recreational function, and amenity. Full stop.
Thank you. Just as a point, Councillor Coombs needs to leave the meeting. We are still 6 remaining, and therefore still quorate. So we will continue. We can adjourn. Yes, Farrell.
Beryl as a local ward member for Wareham. I just wanted to say, do you want to have an adjournment while we consider what?
I was just about to say that.
Thank you.
So we'll have a short adjournment, whilst we get, the form of words that you wish to use ironed out, and if you want to liaise with officers on what those exact words will be, so make sure it's legal. So if we adjourn, we'll adjourn, for, again, we'll make it 10 minutes if we can do it in that time. Thank you very much. We have Beryl has come up with a wording in conjunction with officer and legal advice. And can I ask, Beryl, would you actually read out your reasons for refusal? And I can then ask for a second.
Thank you. Reason for refusal. The proposed increase in hours of operation will lead to an increase in noise and general disturbance from the use of the site at night in a semi-rural location close to a retirement park home site, resulting in substantial harm to neighbouring amenity, which would not outweigh the benefits, and be contrary to policies P3, living conditions and pollution of the National Planning Policy Framework 2026 and Policy E12, whatever, and of the Purbeck Local Plan. Thank you.
Thank you, Beryl. So we open it back up to the committee. If we want to continue debate, if somebody wants to second it. Do we have any hands? Councillor Robinson.
Thank you, Chairman. Councillor Julie Robinson, Ferndown South. I am more than happy to second this proposal.
Thank you. Do you wish to add any further comments?
No, I've listened to the debate. It's been a very fair debate.
Thank you. Is there any further comments before we move on to voting? Any? Councillor Bryan.
I find myself in a very difficult position now, because when Councillor Coombs put forward her proposal, the thing I objected to on that is it didn't stop the current breach. And I do feel that that should have been stopped, because they are technically trading outside their planning consent on a daily basis. Had the proposal at that stage shown that we were to stop them on the breach, and then we would discuss with them the benefit of having the insulation, the protection for the residents from noise and light. Had they agreed on that and we'd agreed that it was suitable, then I would have been more than happy to have supported that particular part. But because it didn't stop them doing what they're doing now, that gave me a difficulty, because we're supporting them in their breach. And I think that creates a bit of a technical precedent issue. So as I say, I would have been more than prepared to support Tony's amendment, had it been that we stop them doing what they're doing now, which is outside the planning consent, and then we negotiate with them on the insulation to make sure the residents not only get less noise but less light on a permanent basis. My fear is, and I understand where you're going, Beryl, my fear is that this will go to appeal, and we will then not have the ability to bring in the screening that will protect the residents. And I think, in hindsight, and I've been corrected by the legal officer, quite rightfully, I should have raised this at the earlier stage and explained why I was so much against what Tony had proposed and the officers had put together. So I'm hopeful that we will find our way to get back to the proposal that was put forward, but then amend it so that we notify the applicant that they are in breach of their current planning, and get them to agree to stop that until such time as we've sorted out a way in which we can protect the residents from the noise and the light. That's where I stand, Chairman.
Thank you. I've just been reminded that there is actually a word in change on this proposal, which is that it's not a retirement park site. As I understand it, it's for over 55s who are not retired necessarily. They're not state pensioners anyway. And it should read residential, not retirement.
Most people are going to be, but it's making. Yeah.
Well, so first question is, Beryl, would you be happy with that change of wording from retirement to residential?
Chairman, no. Can we put then, when it's retirement? I mean, my son retired at 55. I'm sorry, but you can retire at 55. You're able to.
The age restricted part.
Yeah, I mean, you could put age in there.
Age restricted.
55.
Yes.
So age restricted.
55 limit. So
Age restricted is you accept.
to 55.
Age restricted.
Yeah. If we could put that in, please.
Okay. So,
Sorry, I just didn't want to.
Julie, are you happy with that change?
Yes, I am, Chairman.
Thank you. So if I can sum up where we appear to be, we have a proposal on the table, which, if it passes, is the decision of the committee. If it falls, we may get a further proposal which would revert us to the previous proposal with an amendment. Is that correct?
Correct.
So, if everyone is clear on what the options are, is there anyone else wanting to add to the debate before we take a vote? Councillor Bryan.
Yes, thank you, Chairman. Councillor Bryan, representing St Leonard's and St Ives, a little distance away from where we're discussing at the moment. My fear is that if we go for, and I understand where you're coming from, if we go for the refusal that's on the table at the moment, and they went for appeal, we will not be able to protect the residents. And my sole object is to protect the residents from the noise and the light. So I'm not sure whether I'm correct in doing this, Chairman. Apologise in advance. I am going to ask Councillor Ezard whether she would consider my amendment as being, because it's more beneficial to the residents than just stopping it. Because my fear is that it will be won on appeal. And then we have no control whatsoever. At the moment, we have a control.
You're not amending, you're not trying to amend the current proposal.
No, I'm not. I'm asking Beryl whether she would withdraw it.
That was what I was trying to establish, yeah. Which is a fair question. Councillor Azad?
Absolutely not.
Okay.
Thank you. Okay, any further comments before Councillor Skeets?
Is it in order to ask Julie Robinson to consider not seconding?
As far as I'm aware, you can ask whatever questions you like.
Mr. Chairman, I feel the same way as Ray does. I want to protect the residents, but I don't see Beryl's in the short term. It might have some impact until appeal. I'm of a mind now, having listened to all of what the officers have said, that will get turned in appeal, and that means that one, it will cost council taxpayers money, time, and also, and I don't think it will protect the residents in the long term, because the acoustic fencing is something that you will lose. And I understand where you're coming from, but I'm appealing to you, Julie, to consider backing out of seconding the amendment, the proposal, because I don't see any other way that would benefit the residents.
Councillor Robinson.
Councillor Julie Robinson, Ferndown South. No pressure then.
Sorry.
I understand where my colleagues are coming from. And yes, I do support what Councillor Izzard says, it's her ward. What really does concern me is the fact that they are operating these hours now. How long have they been doing 24-hour? Was it from the get-go, or has it just been the past couple of weeks? Will they be written to? Will they be hauled over the coals? Will they be fined? Because what does concern me is that any conditions that are put in place, they're not going to take any notice of. I need a couple of minutes to think about this, Chairman.
Chair,
Councillor Brown.
if I can help a little bit, one of the things I discussed with the officers was immediately issuing, obviously it has to come from a separate department. We'll talk to Shane on that straight away. So then we immediately issue a breach of their current planning, which is obvious. You know, they changed the website, they've done everything that they thought they were going to be able to do if they succeeded in getting planning. So I'm hopeful and fairly confident that officers will agree to go for a breach of planning at that stage. It still means we'll have a few months where there's not much we can do about it. But then we're in a position where we can say, right, this is what you want to achieve. This is what the residents want to be protected from. And that's what we've agreed. And we deal with it in that way. So we immediately go for a breach of planning on their current planning. And that would be my proposal to the officers, which would mean that we've then got things moving along.
Thank you, Ray. Conscious that we're sort of repeating ourselves.
Yes, I know.
In a bit of a loop. Councillor Robinson.
Thank you, Chairman. Can I just come back on that comment? So, in actual fact, then, if we go for a breach, it makes no difference. Because if this goes through, what they're doing, they're just going to carry on doing anyway. So,
I think at the moment, you've expressed your position very clearly, and of the impression that Councillor Robinson is still seconding Councillor Izzard's proposal. Is that correct?
that is correct, Chairman.
Okay, so we have a proposal. Councillor Morgan, are you indicating to speak or?
Yes, it's Councillor Morgan representing the capital of East Dorset, Wimborne. It's a difficult one, this. I was at first in my mind going to, having heard everything, going to, oppose it. But experience shows that yes, they can go to appeal, and depending what the inspector decides, it can of course be overturned. I think it's important, and I go along with what's been said, and I'm thinking about the protection of the residents. I mean, my fear is that if it does go ahead without what we've proposed with the fencing, etc., or trying to make it a lot better for the residents, that it will get overturned. We shall lose what we proposed. And I think as far as the residents are concerned, it will probably only get worse. Because once it's an attraction, and I'm thinking of the antisocial behaviour, of which we've got plenty in our area, and once it starts, very difficult to stop it. And I can see, and I hope it wouldn't happen, but I could see that this could be a good gathering place for those that wish to gather and make a hoo-ha. And sadly that is mine. So I'm inclined to go along with the first proposal which Councillor Coombs brought. That's my feeling now.
Thank you.
I appreciate what's been said, but experience shows that it might not happen. Thank you.
Thank you, David. My experience on places that are, whether the garage is open or not open, I don't see where it makes much difference to people gathering on a convenient space. However, we have a proposal that's on the table. It has been seconded. So unless there's any more contributions, all those in favour of refusal on the wording on the screen, please show all those in favour. 1, 2. All those opposed? 1, 2, 3, 4. No, there's no abstentions. Everyone present voted. And therefore, this proposal falls. So back to the floor. Councillor Skipps.
Probably jumped in there just too quick, really, but I listened to what Ray had to say. I think his amendment is the best way forward. I'm in sympathy with Beryl and what she put forward, because it's meant in the very best of interest to residents. But I do feel that Ray's amendment would be the best way forward. And if you have proposed it, which I believe you have, then I'm seconding. You haven't proposed it. I did jump in too early. I'll back off for a second.
We haven't yet had a proposal.
Okay.
And what we would need is the actual words.
Yeah.
And I'm presuming that you would want Tony's amendment back on the screen with a small change of wording. So perhaps the first thing we can do is put that original amendment back on the screen. That's the acoustic fencing condition. Thank you. I anticipate this. So what precise change of words, so what precise amendment to that condition would you be proposing? Or would it be an additional condition? Or
just to explain my own contention on what we have in front of us, it doesn't actually stop them doing what they're doing now, which is in breach of the current planning. So I want something that will put them on notice that we're issuing a breach of planning notice. I know it's not for this planning committee to decide, but Shane's sitting behind me, so I can ask for Shane's help on this. That we let them know they're in breach of the current planning, and we've considered their planning, and we're willing to look at it once they come up with a proper proposal for the acoustic barrier to protect. At the moment, we've got 3 months and 6 months sitting up there. Well, 3 months and 6 months to me is too long. I know the residents are going to have to put up in the short term with the noise, but this is the best way forward to get them aware that they really do have to come up with something before we can approve.
okay, so would you then want to change point 1 and point 2 so that it's not within 3 months or within 6 months, it is some other timescale? And how exactly would you want to word that? We have legal.
Thank you, Chair. I was just wondering if I've got this right, and Councillor Bryan will correct me if I'm not, he's looking for a condition which prevents the extended hours commencing unless and until a scheme has been submitted and approved for an acoustic fence and that fence has been erected. I'm seeing nods. Is that correct, Councillor Ryan?
That's absolutely correct. Thank you for putting the words in the correct manner.
In that case, Chair, one option, if Councillor Bryan is happy, is to leave the precise wording of that condition delegated to officers, having established the principles of what Councillor Bryan is requesting in the condition, and then rather than trying to draft quickly on the hoof now, we can deal with that before the permission is issued. As long as Councillor Bryan and you are happy with that, Chair, I suggest that as a possible way forward.
Okay, so the concern is they are currently operating outside of their planning consent. You want that to cease until they have put in place the acoustic fencing, and that enforcement action should be taken if they don't cease. Is that correct?
Partially, Chair. The point I think we're missing is that they are in breach currently. So we should immediately get the officers looking at that breach to see where we stand on that, but then offer them that if they're willing to put in the sound reduction equipment, fencing, then obviously we'd be happy to concede to their planning. But it has to be after officers have thoroughly looked at the acoustic fencing to make sure it achieves what the residents need it to achieve.
So based on Mr. Crowell's legal opinion, you'll be happy to delegate the precise wording to officers to achieve that objective.
Yes, Chairman.
Okay. Do we have anyone seconding that? Councillor Skeets, do you wish to second?
Yes, Andy Skeets, West Morsland, Three-Legged Cross. Yes, happy to second that, Mr. Chairman.
Do we have any further contribution before we move to the vote on that? Okay, so the recommendation is on the screen. The precise wording of recommendation 7 to be agreed with officers. Okay, so let's take a vote. We've got a proposal, it's been seconded. All those in favour, please show.
Can I just ask a question, Chair?
Yeah.
What I'm looking for on there, and I agree with the officer putting the wording in there, and I'm sure acoustic fencing is only at number 7 because we'd already got the first 6. So I can't jump the queue.
It's not a priority, it's just
no.
They're all equal.
Having understood that, I'll now stand out.
Okay.
Yeah.
Right, so all those in favour, please show. 1, 2, 3, 4. All those against? 1. Any abstentions? 1. In which case, P4 2026-02113 is granted, subject to the conditions as discussed in detail. And that brings us to a conclusion and moves us on to agenda item 6. We've had several adjournments. We'll have a very brief one for a comfort break. We are still 6, therefore we are still quorate. We have the next item is P4 2026 03042 Coal Hill First School, Pilford Heath Road, Coal Hill, BH21 2HL, and we'll have a presentation from Kelly Pugh. Kelly.
Thank you, Chair. This application is to demolish the existing structure on site and replace it with a single-story extension. The application is before you today, members, because the because the site is owned by the council. So the site context, the application site is located in Coal Hill to the north-east of Wimborne. The vehicle access to the school is off Cannon Hill Road, which is to the north. Pilford Heath Road runs along the eastern boundary and Middle Hill Road lies to the south. The site is located inside the settlement boundary. The area in purple is council-owned land, which involves all of the sites, the Memorial Hall next door and the library. The area in green shows the extent of the tree preservation order, which also covers all of the site. An area review for you there. The new extension is to the south, where you can see the white building there, covered area to be demolished, to show you where the residential properties to the south are located and to the east, and also where the location of the single-story extension is going to be. Site photos. The photos show inside the site and the structure that is to be demolished with the white roof. The area in the distance on the bottom photo is just to show you where the tree protection fencing is to be located. Side view of the existing covered area to be demolished from both inside and outside the site. You can see building there to be demolished and then outside the gate. So you can just about see its roof. Okay, so just to demonstrate that the site is well screened from the properties on Pilford Heath Road to the east, which is approximately 30 metres away, and properties to the south, which is approximately 40 metres away on Middle Hill Road. Site plan showing is existing and proposed. Existing structure on the left, green area demonstrating where the new extension will be on the right. Existing and proposed rear elevations showing you that it is a pent roof design, 4.5 metres in height and at its highest point, reducing to 2.1 metres and a width of 9.4, which is partially positioned beneath the existing roof structure. Existing and proposed east elevations with a 3.3 metre projection from the rear roof of the building, which is similar to the existing covered area, and with an overall 3.8 projection, including the roof overhang. Materials that are proposed are to be shiplap cladding and an anthracite grey roof tile, which is very similar to what is existing. So in summary, the single-story extension is within the settlement, where the NPPF policy S4 requires that development proposed should be approved unless the benefits of doing so would be substantially outweighed by any adverse effects when assessed against policies in the NPPF. No harm has been identified subject to the conditions proposed. The application therefore complies with both local and national policies. Recommendation is therefore to grant, subject to conditions. Thank you, Chair.
Thank you, Kelly. We have one public speaker on this, who is the ward member, who is Councillor Andy Todd. Andy, please.
I was going to start saying good morning, but good afternoon, everybody. Chair, members, thank you for allowing me to speak. I'm speaking in my role as ward member for Coal Hill, Wimborne Minster East, and as a member of Coal Hill Town Council in support of this application at Coal Hill First School. This is a modest and sensible proposal which will improve an important and much loved community facility. The enlarged covered space and additional toilet facilities will provide practical benefits for pupils and staff, supporting outdoor learning and improving the day-to-day operation of the school. I'm going to go off script here. The material improvement to the conditions for the children and the teachers who are currently on 24-hour cleaning duties will be substantial. I note there have been no public objections to the application and the consultees have raised no objections subject to appropriate conditions. The officer report concludes that the proposal is acceptable in planning terms and recommends approval. As a local ward member, I am keen to see appropriate investment in our educational facilities where it can be delivered without material planning harm. In this case, the benefits to the school and the wider community clearly outweigh a very limited loss of hard surface playground space identified in the report. I therefore respectfully encourage members to support the officer recommendation and grant planning permission. Thank you.
Thank you very much, Councillor Todd. Do we have any committee members wanting to ask a question? Councillor Morgan.
Thank you, Mr. Chairman. Still Councillor Morgan, still representing Wimborne. I think it's good that the school is trying to improve itself. And I think this additional building, which is proposed, and I've studied the plans quite well. And it's good that this is going to benefit the school. I appreciate they might lose some of the play area, but there's plenty there, I can assure you. If I had to declare an interest, which is not really relevant, I mean, I taught there 50 years ago when it wasn't there, if you see what I mean. It was the old school, and we had 7 huts in the field, which was quite interesting. So it was good that, first of all, after 40 years, they decided to build the new school, which is a good addition for that area. I would imagine that the parents support the new extension that is that's going on. It'll benefit the children. And I'm going to be so bold as to say, Mr. Chairman, that I would like to propose that we accept the officer's recommendation.
Thank you. So that's a proposal from Councillor Walden. Councillor Skiggs.
Andy Skeets, Westmoreland and Three-Legged Cross, and I'm happy to second that proposal.
Thank you. And Councillor Robinson, you've got a hand up, but you are.
Councillor Skeets beat me to it.
Oh,
Chairman.
sorry.
Okay. I just saw him first. So, do we have anyone else wishing to make any further comments? Councillor Bryan.
I've got to say it's nice to see a proposal come forward that is as a foregoing or a forward-thinking protection for the children of the area. I totally support this. If my colleagues hadn't beat me to it, I would have been very happy to have proposed. But it is nice to see development of some of our property in making this a venue that is far more suitable for the children of the council's area.
Thank you, Councillor Ryan. Any further comments? We've had a proposal. It's been seconded. If there's nothing else to ask, we'll move to the vote. All those in favour of the recommendation, which is to grant subject to the conditions, and that looks like it's unanimous. So everyone raise their hand. There's no objection. So in that case, it's approved. P for 2026-03042 is unanimous. Colford Hill First School, Colford Heath Road, Colford Hill BH212HL has been unanimously approved. We have, the next item is urgent items. There are no urgent items, and there is, agenda item 8 is exempt business. There is no exempt business. At which point at 12:33, I'm going to declare the meeting closed. However, we have some information coming our way